We often hear about companies moving their headquarters from one country to another. Why is that?
Shareholders can indeed decide to transfer their company's headquarters from one country to another for several reasons. For example, the shareholders might move and want their company to be managed from their new country of residence. Or, the company may have had operations in a foreign country and was incorporated there for good reasons at the time, but those reasons no longer exist, and the shareholder now wants the company to return to Europe, for example, or to their country of residence. These are mainly substantive reasons, to align with reality and the place where the company's actual management is carried out.
Is this process easy?
This process was still fairly simple until recently. However, a European directive on mobility was transposed into Belgian and French law in 2023. Not yet in Luxembourg. This directive strengthens the rights of stakeholders. These are all the people connected to a company: staff, shareholders, creditors, suppliers, tax authorities, and as a result, the administrative formalities required to carry out a transfer of registered office have been tightened, notably with double legality checks and mandatory minimum timeframes.
That seems quite complicated in a context where Europe actually wants to make mobility easier.
It is paradoxical, indeed. First of all, before getting started, you need to check what assets make up the company and their current value. In fact, the migration of a company from one country to another is generally considered, from a tax perspective, as a liquidation. As a result, at the time of its transfer, the company realizes its assets and liabilities at their actual value as if it were being liquidated. If there are any unrealized capital gains, they will be taxed under the corporate tax of the relevant country. For a holding company that mainly owns shares in other companies, if those shares benefit from the parent subsidiary regime, the unrealized capital gains will be exempted. If a permanent establishment is maintained in the original country, the transfer will not be considered a liquidation. This will be the case, for example, if the company keeps a building in the original country or maintains an operational activity.
To sum up, seat transfers are becoming more complex in Europe, but they can still be completed within 2 or 3 months. From a tax perspective, the transfer is treated as a liquidation and unrealized capital gains are taxable.
Yes, that's right, although in some cases there are exemptions. We are at your disposal to analyze the prerequisites before any transfer.